Hello, I'm A.G. Harmon, and I am the Associate Dean of Bench and Bar Programs here at the Catholic University of America's Columbus School of Law. Welcome to the fourth annual Seigenthaler debate, one of Catholic law's First Amendment initiatives. The purpose of the initiatives is to provide a collegial forum that fosters debate, dialogue, and study of First Amendment issues from all sides. Catholic Law is proud to be a leader in this area of legal education and hosts this program, along with the Seigenthaler Sutherland Cup First Amendment Moot Court Competition, which is now in its 75th year and the oldest moot court competition of its kind in the nation, and the Judicial Clerkship Opinion Writing Conference. The fifth year was observed this year, and of course our Center for Religious Liberty. This debate is co-sponsored by our school's chapters of the Federalist Society and the American Constitutionalist Society. We thank them both. The Seigenthaler debates features two First Amendment scholars engaging a free speech issue that is to be mooted during the upcoming Seigenthaler Sutherland Cup competition. The debates are named after John L. Seigenthaler, journalist, publisher, and free speech advocate. The resolution that is the subject of this year's debate is resolved. Governmental destruction of a traditional site of worship on government-owned property requires a strict scrutiny analysis under the First Amendment. Each position, pro and con, will begin with an opening statement on the topic, followed by questions from our moderator. After that period, time permitting, the judge will pose questions from the audience posted in the chat feature on this webinar. So we encourage you to post questions in the chat feature. Participating in our debate and taking the pro position is Josh McDaniel. Josh is an assistant clinical professor of law at Harvard Law School and faculty director of the school's Religious Freedom Clinic, where he supervises students representing a diverse group of religious clients. His areas of interest include civil rights and liberties, constitutional law, and religious freedom and free exercise issues, especially as those issues concern religious minorities. Josh is also an associate scholar with the Center for Law and Religious Freedom at Jagiellonian University in Krakow, Poland. Taking the con position is Lyle Weinberger. Lyle is an associate in the Washington, D.C. office of Gibson, Dunn & Crutcher. He practices in the firm's litigation department and with the appellate and constitutional law and administration law practice area groups. Before joining Gibson Dunn, Lyle clerked for Justice Neil Gorsuch of the United States Supreme Court, Judge Frank Easterbrook on the 7th Circuit Court of Appeals, and Chief Justice Daniel Eisman of the Idaho Supreme Court. Lyle also taught and researched at Harvard Law School as a lecturer, as the Owen Searle Smith Fellow, and as the Raoul Berger Mark DeWolf Howe Legal History Fellow. He will join George Mason Law School's faculty in the fall to teach constitutional law, among other areas. Finally, our moderator of the debate this evening is Judge Paul Mady of the Third Circuit Court of Appeals. A friend of the law school. We're greatly honored to have him participate as a moderator here tonight. Prior to judicial service, Judge Mady was a partner at the law firm of Lowenstein Sandler, LLP. He previously served as general counsel at the University of Hospital Newark and deputy chief counsel to the governor of New Jersey, and is assistant United States attorney in the District of New Jersey. I'll now turn things over to Josh McDaniel to begin with his opening statement, to be followed by Lyle Weinberger's opening statement, and then Judge Mady's round of questioning for both sides. At around 5:50, Judge Mady will pose any questions that have been posed in the chat feature of this webinar, or follow up with any questions or comments the debaters would like to make before we conclude. So Josh, over to you for your opening statement.
Great. Thank you very much for having me, and it's good to be here with Judge Mady and my friend, Mr. Weinberger, with whom I go way back to my early days teaching at Harvard Law School while he was a fellow here. And of course, it's especially good to be welcomed here by Catholic University. Have a lot of friends there. So I'm given to understand that the students have briefed and are preparing to argue a fact pattern involving the destruction of a sacred site of worship, and you're arguing whether the government's action is lawful. But I understand the topic of our debate here to be slightly different and a bit broader. We're focusing on the appropriate standard to be applied to this kind of case under the First Amendment's Free Exercise Clause. So we're bracketing the question of how the case should come out under the Religious Freedom Restoration Act, though there are some overlapping issues there. and I might point to some of the fact patterns from recent cases that were resolved under RFRA. Now, of course, the elephant in the First Amendment room here is a case called Ling versus Northwest Indian Cemetery Protective Association. Um, Quite the organizational mouthful. Um, and Ling, I would argue, is a terrible, no good, very bad decision. So I'll start by orienting my discussion around Ling, and hopefully that should help guide some of the analysis here. So to start, I want to make one thing very clear, and that's that the question to be resolved in this debate is whether government destruction of a traditional site of worship on government-owned property requires strict scrutiny. And Ling doesn't answer that question. I say Ling doesn't answer that question because Ling wasn't about government destruction of a site of worship. Read Ling carefully, and if you look at the court's description of the facts, the government went to great pains to avoid physically destroying any traditional site of worship. The facts in that case were that the government wanted to complete a proposed 6-mile stretch of road in the Chimney Rock area, and it also wanted to harvest some timber in that area. There were numerous sacred sites in the general area, but the government wasn't proposing to bulldoze the whole Chimney Rock area. The proposed road, this 6-mile stretch of road, was, and now I'm quoting from the court's opinion, it, quote, avoided archaeological sites and was removed as far as possible from the sites used by tribes for specific spiritual activities, end quote. And as for the timber harvesting, the government went out of its way to identify each and every site of worship, drew a mile-wide protective zone around each one, and said it wouldn't harvest any lumber in those circles. And as far as I can tell, the plaintiffs in the Ling case didn't dispute that the government's proposal not only avoided destroying any site, but placed the road as far as possible from those sites, and then went even further and put 1-mile wide protective zones around each site. So instead, the plaintiff's argument in Ling was that the government hadn't done enough because although the government's action would stay quite far away from any specific site of worship, the government's action in those other faraway places would disturb the sacredness of the general area and would diminish plaintiffs' ability to enjoy their spiritual practices at the sites of worship that were not being destroyed. So my first argument is that Ling doesn't answer the question we're here to discuss. And in fact, we're here to discuss the reverse situation. What if the government targets and callously destroys a specific traditional site of worship? Should that get any meaningful scrutiny under the First Amendment? So to kind of sum up this point, they say that cases with bad facts make bad law. And as Justice O'Connor pointed out in Ling, the plaintiffs there were asking to uphold an injunction that would have permanently blocked the federal government from building a road or harvesting timber, quote, anywhere within an area covering more than 17,000 acres of public land. So of course, when that's the ask, it's perhaps unsurprising that the court will say that the free exercise clause can't tie the government's hands to that extent. But if Ling is read to stand for the proposition that the First Amendment is never implicated when the government overtly targets and destroys a specific traditional site of worship, that's making bad law. Now, I would point, now I said I was going to point to just a couple of RFRA cases. So one case I wanted to point to is a case called Slockish that was decided a few years ago in the Ninth Circuit. There, I think that's kind of an interesting counterpoint to the facts in Ling. The government there wanted to widen a road that abutted a small strip of land that was sacred to indigenous groups. It could have easily met all of its objectives in a way that would totally avoid destroying the sacred site, including one option was it could have simply widened the road on the other side of the road, but it instead bulldozed the sacred site. I would submit that's a very different case from Ling, and that is an example of a case where I think most people would agree that strict scrutiny should apply to those types of facts. Now, I don't need to argue against Ling because Ling is completely distinguishable, but I can even make the case that Ling was wrong, and I think explaining why can help to explain the proper way to think about this. So the first question in free exercise analysis is whether there's a cognizable burden on religious practice. If there's a burden, then strict scrutiny applies. So the question is interference with a traditional site of worship a cognizable burden? Ling said the free exercise clause doesn't protect against incidental effects of government programs, which may make it more difficult to practice certain religions, but which have no tendency to coerce individuals into acting contrary to their religious beliefs. Some have read this to mean that coercing is a burden and penalizing is a burden, but rendering religious exercise utterly impossible doesn't count. On that score, Ling, if that's the way you interpret Ling, it was completely wrong. For the textualists out there, we can start by defining the verb the free exercise clause uses, which is prohibit. The federal government cannot prohibit the exercise of religion. And one of the two key accepted definitions of prohibit is to prevent from doing something. Or as Justice Alito put it recently in a case called Fulton, the normal and ordinary meaning of prohibit in 1791 as today is either to forbid or to hinder. And that's exactly what we're talking about here. There can be no question that destroying a sacred site prevents or hinders religious worship. And for you First Amendment old schoolers out there, we could also go to the source, the first case that announced strict scrutiny for First Amendment free exercise challenges, Sherbert versus Werner. It explained that while yes, coercing action contrary to religious beliefs, of course counts as a cognizable burden, Justice Brennan explained in that case that even more obviously, the free exercise clause requires strict scrutiny when, quote, the purpose or effect of a law is to impede the observance of one or all religions, even though the burden may be characterized as being only indirect. So yes, I would argue even interference is a burden. But let's get back to the question at hand, which isn't interference, but is the much easier case where the government outright destroys the traditional site of worship. If interference is a burden, then destruction obviously is. I don't think my friend on the other side of this issue would dispute that forcibly demolishing a synagogue, a mosque, or a cathedral over a religious group's objections would burden religious practice in that way. So that then brings us to one of the distinguishing factors of these cases, which is the fact that it's on government land. So my first response to that would be that last I checked, there's no free pass in the First Amendment for the government to infringe the free exercise of religion so long as it does so on its own land. And if anything, the fact that the government owns the land can make it more worrisome. As Professor Stephanie Barkley has pointed out, there are some situations where religious people's ability to practice their religion is completely at the mercy of the government accommodating the practice. For example, think prisons, where if the government doesn't provide or permit kosher meals, Jewish inmates simply can't keep kosher. And of course, there's and here that's exactly what we have here as well. If the house of worship is on federal land, the religious practitioners are completely at the government's mercy. In those contexts, strict scrutiny is especially important. And of course, there's a certain irony when the government invoking the reason that the government is invoking the reason that it's government land, so therefore a special standard should apply. But it's only the government's land, of course, in many cases because indigenous peoples were divested of their land, and their religious worship in many of these cases predates the government's ownership. Um, so some final remarks as I close out here. So one is I want to point out that just because strict scrutiny applies doesn't mean the government wins. As the Religious Freedom Restoration Act, as Congress nearly unanimously said when it passed the Religious Freedom Restoration Act, the strict scrutiny test in cases like Sherbert is a workable and sensible test that courts can use to reach needed outcomes. Take the recent Apache stronghold case in the Ninth Circuit, for example. In that case, there's a giant body of copper ore under a sacred Apache site called Oak Flat in Arizona. The copper ore is worth an estimated $2 billion. I'm not saying the free exercise clause precludes the government from accessing the minerals, but what we are saying is that rather than give the government a free pass in all cases, no matter how unnecessary, my suggestion would be that the government should at least have to explain why accessing the minerals is compellingly important and why blowing up the site is the only way to access them. This is an important feature of strict scrutiny. It's an important purpose of the way the test works. By requiring the government to justify its action under the least restrictive means test, the parties and the court can hash out whether there are any viable alternative means of accomplishing the government's objective without destroying the religious site. For example, say the government could find a way to drill in from the side of the land rather than completely obliterating everything on top and creating a crater. If the strict scrutiny process could uncover that possibility and require the government to explain why that's not something it could do, I think that's a very sensible and healthy result. If we say, however, that the strict scrutiny doesn't apply, we short circuit that whole process, and the government doesn't have to provide any justification and doesn't even have to even consider any alternatives. And I'll conclude with one last example. The Ebenezer Baptist Church is the church where Martin Luther King Jr. preached, and it sits within a national park. So my last question would be, does anyone think the government can go in and bulldoze that church without the First Amendment having anything to say about it? I would say, of course not. Destroying such sites directly prevents people from being able to practice their faith and should thus be one of the types of government action the First Amendment most centrally protects. So with that, I'll rest and turn it back to Professor Harmon.
Thank you, Josh. And now I'll turn things over to Lyle Weinberger for his opening statement.
Thank you, Professor Harmon, and thank you to Professor McDaniel. And it's a real pleasure to be here with my friends at Catholic University and a friend from Harvard. And we have talked and collaborated on a variety of religious liberty subjects. So unsurprisingly, there are many areas of agreement between us, but also some disagreement. So let me start by saying that a couple of the areas of agreement. So certainly, I think when there is good evidence that the government is targeting a religious entity, even on federal land, I agree with Professor McDaniel that there strict scrutiny would be triggered under the First Amendment. I also agree with Professor McDaniel that completely destroying a religious site is certainly a type of restriction on religion that, as he mentioned, there is the passage in Ling that talks about coercing and penalizing. And then some have argued whether anything further, including completely destroying, also counts as a restriction. And on this, I agree with Professor McDaniel. Yes, that certainly does. But what are the limits to which the First Amendment can restrict the government's use of its own land? And here, I want to make the case that it's actually a hard issue. And in saying this, I want to start with the premise that not all bad ideas are unlawful. So take the example that Professor McDaniel gave from Apache Stronghold, this decision to transfer lands from the federal government to a mining company to enable mining that will end up in the destruction of a sacred site to the Western Apache. It's catastrophic for the Western Apache's religion and culture. And there are good reasons to see this as a very bad idea. However, the fact that it's a bad idea does not necessarily mean it's a violation of the First Amendment or of the Religious Freedom Restoration Act, or that it triggers strict scrutiny. The big picture I want to suggest is that there would in fact be a real problem if this did trigger strict scrutiny on federal land without some specific evidence of targeting native religions or in other contexts targeting religion. Indeed, this would work a fundamental transformation of the government's obligations in regards to religious exercise and change the structure of free exercise from what we can roughly describe as a negative rights framework to a positive rights framework. So quickly, I want to hit three main themes here. One is a quick word on the concept of negative rights versus positive rights. Second, I want to look deeper at the First Amendment. And then third, I want to look at some of the overarching policy challenges that come here in thinking about how we structure a regime of religious liberty when it involves government action. So first of all, negative rights and positive rights. historically, the right to free exercise of religion has been understood as a negative right, which is something that protects you from something being done to you. It's a right to non-interference. On the other hand, a positive right is a guarantee that something will be done for you, a right to provision of some kind of good or service. So if the government wants to stop you from engaging in your religious exercise, the negative right can protect you from that government interference. On the other hand, if you want the government to provide you with something that you need to exercise religion, then you're making a rights claim that sounds in positive rights. If the government is already providing goods or services, you have a grant program that supports schools of all sorts, then free exercise requires equal treatment. But where the government does not already have a provision of goods or services on a general basis, the free exercise right does not, on the face of it, provide you with an entitlement for the government to support your religious exercise. And the problem that comes up when we have a sacred site on government land is that the religious claimants don't own the land. They don't have a legal right to the land. What instead they're seeking is a religious liberty right to access land that belongs to the government. It's a kind of easement for religious use on government land, or a servitude. And in economic terms, it's a subsidy for religious exercise. That may or may not be a good idea to have, but it's not what the Constitution provides for. So the First Amendment says that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That's a classic negative rights formulation. Congress shall not do certain things. The question here is whether the government can restrict my religious exercise by what it does with its own land. Or put it in other words, can I bring a lawsuit and get strict scrutiny from a court when I say the government is managing its own land in a way that interferes with my religious practice? And I think the answer is that the government is not under an obligation to use its own property in the way that best facilitates the religious exercise of others. And on this point, I think Ling is basically correct. Remember, again, this is the case. There's a road that's being constructed in California. It's passing through national forest, and it's coming close to a sacred site to Yurok, Karok, and Tolowa Indians. And it's not destroying the site, but it is destroying some of the environment around the site. And according to the uncontested testimony in the case, that was going to have negative impact on the spiritual practices that were taking place on the sacred site itself, because the sacred site is supposed to be undisturbed. And the Supreme Court said that this was not a violation of the free exercise clause because the Constitution didn't create an obligation for the government to run its internal affairs in the way that best facilitates religious exercise. The Supreme Court was building on another case from just a couple years earlier called Bowen against Roy, where parents had brought suit saying that they believed that Social Security numbers spiritually harmed their child if they were used to identify the child. And they objected to federal laws that required the use of Social Security numbers in certain welfare programs. And the Supreme Court again rejected the free exercise claim, saying that the way the government conducts its own affairs is not prohibiting the free exercise of the parents' religious beliefs. And the court went on to say that the free exercise clause simply cannot be understood to require the government to conduct its own internal affairs in ways that comport with the religious beliefs of particular citizens. The free exercise clause is written in terms of what the government cannot do to the individual, not in terms of what the individual can extract from the government. And consider for a moment the implications of going the other way. A sincere individual who believes that a massive amount of land is sacred could litigate any number of practices that the government chooses to permit or prohibit. Choices about timber harvesting, about hunting, fishing, rock climbing, decisions about road construction, road maintenance, about fencing or lack thereof, about law enforcement on federal lands, border security, and so forth. Moreover, I struggle to think of a principled reason to limit the government's obligations to use its property to real property. What about the government's building usage? What about the government's money? Could there be a First Amendment claim by a would-be religious pilgrim who cannot afford to go on pilgrimage, but then seeks to have a government grant to subsidize his international travel? It is the government's property, and it could use that property to facilitate greater religious exercise that wouldn't otherwise be possible. So there are, I think, very great difficulties once we make the move to saying that the government has an obligation in order to facilitate free exercise to provide the use of its own property to that end. Now, in saying that, I completely agree with Professor McDaniel on another really important point that he made, which is that Native Americans in America are the ones who have suffered most regarding access to sacred sites on government lands. And very often their lands were taken from them through various kinds of misconduct on the part of American government and American settlers. What I'm worried about with this is whether an expansion of the understanding of what counts as free exercise of religion is the right way to remedy what are real wrongs that were committed historically. And if we look at the prison context, for instance, the first wave of defense here for facilitating religious exercise was actually statutory and regulatory in terms of what prisons do to provide religious access to those who have been restricted in their freedom. And to the extent that we're going to draw analogies here to the situation of Native Americans who have been restrained from accessing their sacred sites, we may think that a statutory and regulatory approach providing access would be better suited to managing the potentially conflicting concerns here than doing this through the courts. So in conclusion then, free exercise protections, important, precious, but they don't solve all the problems. And destruction of ancient sacred sites may be an epically bad decision, but stretching the First Amendment to new lengths to solve the one problem may lead to a cascade of others. And with that, hand it back to Professor Harmon.
Thank you, Lyle. And I'll turn things over now to Judge Paul Mady, who will conduct the questioning section of the debate. Judge Mady.
Professor Harmon, thank you for the opportunity to join this fascinating conversation tonight. And I want to extend my compliments to the insightful opening remarks from both of our participants. Let me start by asking either of you, how big of a problem is this when we are talking about religious practices on public spaces? Is this a recurring fact pattern that should challenge our normal understanding of the First Amendment, or is this an unusual set of circumstances unlikely to replicate so that the courts should be mindful about carving out new exceptions?
I'm happy to start with that. So I would argue that this is not an issue that we are seeing a lot. We've got the Ling case in the 1980s. We've had a small handful of other decisions, mostly cropping up in the Ninth Circuit, where there's a particularly plentiful amount of federal lands on which indigenous peoples are worshiping. So it's not an issue that we see a whole lot, I would argue.
And I would agree with Professor McDaniel on that. I do think that one reason that we don't see this a lot is because Ling has made it very difficult to bring this kind of challenge. And one thing that we may be concerned about as we look at the possibility of expanding access to strict scrutiny for matters on government lands is that we might find, I think one of the concerns is then it's difficult to cabinet to the land context and it becomes broadly government property, and that then we might well see creative litigants bring a great number of formulations of lawsuits about this to test the outer limits. And the question then is, what would the outer bounds be for government obligations to at least undergo strict scrutiny regarding the use of government property in regards to religion?
Yeah, it sort of leads to my next question, which is, does this sort of risk a kind of adverse possession by expressions of faith? I mean, you can imagine the slippery slope of hypotheticals of what if a group of sincerely believing folks decides to camp out on any particular public space and declare that it is a necessity that they have access to this space for their religious practices. Where would we draw the line from those kinds of actions and the sorts of suits you've talked about in the Ninth Circuit?
So I can start with that. So so the question that we're looking at here is obviously a traditional site of worship. So I think these are easier cases in that sense, because you have a site where I don't think in most of these cases there's any dispute that there's a long and pretty well established history of these sites being used for religious purposes. But that's also why I would draw the distinction about Ling and other cases like Apache Stronghold and the Slockish case that I mentioned, where I do think that you have a different set of questions and issues that come up when religious claimants are not complaining about the destruction of, like, the physical destruction of their site of worship, but are instead complaining about something that the government does potentially miles away from that specific site of worship, and arguing that that interferes with their subjective spiritual enjoyment or development. That I think is a lot harder of a question. It's not really the question that the debate is focusing on, but it's a harder question that I think does raise questions in terms of whether that qualifies under the substantial burden analysis.
Well, I don't know if you wanted to follow up on that.
Yeah, so I think one of the challenges with the an expansion of kind of, if we discard Ling, if we then are using the First Amendment to conduct strict scrutiny of government decisions of what happens on government property, the use of the historicity or longstanding tradition of a particular piece of property, it is a helpful way of limiting the scope of what kinds of claims could be brought. But that also strikes me as it's a new piece of a free exercise analysis, in the sense that it can be evidence of sincerely held belief, but the standard doctrinal articulation is that if someone invented a new religion last week and they also have a sincere belief, then they have the same ability to make these claims. So getting to Judge Mady's point about possible adverse possession, one might worry about the sincerity if these kinds of claims were easier to bring, and if then the number of the claims began to multiply, one might wonder about that. And this is not unique to this area of First Amendment litigation, for sure. This is something that is a recurring challenge in First Amendment law, where the courts are reluctant to second guess the religious beliefs of individuals. Certainly they are prohibited by the First Amendment from telling people that they're wrong about their religious beliefs. But then if there is a sincerity question, it's a very uncomfortable one for the courts to have to wade into. And occasionally it has to be done, but this could prompt more. But again, I don't think that's unique to this area of law.
Well, I want to stay with you for just a second, because one of the points that the professor makes is that this is not a guarantee that the United States will lose all of these actions. Rather, it's simply a requirement that they have to explain their justifications and that there is no lesser burdensome way to go about that. So, given the context in which we are speaking, which is this constitutional restriction on federal power, why isn't it a natural judicial response to hold the United States to the burden of its arguments?
Yeah, so there are many things about that that are very appealing. That I want the government to have good reasons for what it does. I want them to not cavalierly target people and do that under cover of, well, we're just, we're building a road, when in fact, without judicial scrutiny, it could be easy to get away with anti-religious targeting and all kinds of problematic activities. But at the broadest level, subjecting any government activity to a strict scrutiny level of analysis is a quite intrusive imposition on government decision-making. Government having to come into court, having to explain what it's doing, having to consider and be able to document that it considered all of the possible alternatives. That is a heavy burden. And I think here the concern is in part just that the process is the punishment. They may be able to, in the end, carry out some of these activities, but if every single decision over, some of these cases are involving 17,000 acres, I think was Navajo case from the Ninth Circuit. These are often large areas of land. And if every decision about road renovation, about hunting permits, and so forth, has to then be interrogated at the level of strict scrutiny, that makes federal land management just a totally different administrative process. So is it the worst thing in the world to say that, oh, the federal government should have to explain everything? Certainly, it's not the worst thing. But I think the question is that actually required by the First Amendment? And in the managing of the government's own property, I don't think that's the case.
Professor, just sort of following back up to you then, does this turn development of public lands into a sort of another layer of kind of quasi-environmental like review where you're bogged down in endless analysis of harms and alternatives that really have the practical effect of limiting development of the use of the sovereign's property at all?
I don't think so. And one data point that I would point to on that is that we have the RFRA context where where strict scrutiny applies to all federal government actions. And you've got a circuit split, a number of circuits that have not. So the Ninth Circuit, for example, has basically grafted Ling onto its interpretation of RFRA and have imported all of Ling's analysis into RFRA. But other circuits don't do that. Other circuits take a what they call a plain meaning approach to substantial burden under RFRA. And the thing I would point to is that I don't think that we've seen any kind of floodgates being open in terms of everything being bogged down and every project being shut down, and or a wave of litigation in those other circuits where the courts have taken the different approach under RFRA.
This discussion is built on a series of cases, Sherbert, Smith, Yoder, that are familiar to law students, but are growing rather ancient in their pedigree. Is this, do you look at these controversies as an opportunity for the court to apply those decisions or take a fresh opportunity to reconsider the foundations of those holdings more broadly? No, offer that to either of you.
So I'm happy to start on this one. I think this may be another area where Josh and I come at this from a little different perspectives. So I think that as a matter of kind of system design, I actually would defend the existing constitutional framework, and which is the Employment Division v. Smith framework that says if a law is neutral and generally applicable, it doesn't raise a free exercise problem. But then couple that with RFRA, the Religious Freedom Restoration Act, a statute that provides for means for strict scrutiny evaluation. And I think it's defensible, first, that we want fewer things to be constitutionalized rather than more in a polity that is diverse and dynamic. And once you have constitutionalized something, it's very hard to permit, it's very hard for a government to act in that area. And it's preferable to have these matters, the nitty-gritty aspect, governed more by statutes, which can be fine-tuned. Not that Congress is very fast in changing or fine-tuning statutes or anything these days, but RFRA, I think, is preferable on kind of democratic accountability norms as a way of managing the details of a religious exemptions regime, while the First Amendment, under the Employment Division v. Smith framework, provides a backstop that prohibits targeting of religious bodies. And so then where Ling fits in here, Ling is at this kind of ambiguous point. And in the recent Ninth Circuit litigation about Apache Stronghold, there were lots of debates about whether Ling is more a part of the Employment Division v. Smith world, which talks about neutral laws of general applicability, or is it more a part of the Sherbert and Yoder world, where the court applied strict scrutiny through the First Amendment? And these are two different. This is the big argument for many years now in First Amendment free exercise law, and Ling exists between the two and in some ways independent of the two. So I'm not sure that this will be the domain through which any of these things would be reconsidered. But so my main desideratum here would be, if we could have, if we could adjudicate most of this through something like RFRA, or even if Congress was ever able to do something further, we could even have a RFRA specific to tribal or indigenous sacred sites on government land. Then that would be somewhat more akin to the way that we handle penal institutions, and have some slightly more tailored statutes there. So I like the statute approach as the first level of defense.
I can speak to that a little bit as well. So I agree with a lot of what Lyle said. I agree that it's a healthy and a good thing for RFRA to provide additional statutory protection. I think in a lot of these cases, there are, for example, separation of powers reasons why courts are going to be reluctant about about bringing in some kind of robust judicial review in areas where the political branches are deemed to have plenary authority. So one example of this would be the prison context or the military context, where in the First Amendment context, courts have had a more hands-off deferential approach. But now we have RFRA, and courts are, because of the kind of separation of powers effect of RFRA, of Congress coming in and requiring courts to get involved, courts are taking a more active role. And for that reason, also, I would really disagree with the Ninth Circuit's conclusion that RFRA simply incorporates Ling whole cloth. I think that's not consistent with prior Supreme Court cases like Burwell versus Hobby Lobby, explaining that that RFRA was intended to broaden beyond the First Amendment and provide more expansive protections. But all that said, I think Smith was the culmination of a series of decisions, including Ling, including other decisions like Bowen versus Roy and Goldman versus Weinberger in the military context and others that chipped away at religious freedom. And my take is that Congress's passage of RFRA wasn't just reflecting a judgment that, hey, it would be nice if we had some statutory protections, but it was a bipartisan agreement that the Supreme Court over time had gone off the rails with these prior Supreme Court cases, especially the ones from the 1980s, and Congress nearly unanimously pointed back to Sherbert and Yoder, these original cases from the 1960s and 70s, and said that that was a very workable, good approach, and we want to return to that. So again, you might have some situations like the military context where I think there's some good reason to differentiate between how courts should proceed on constitutional claims on the one hand, and how they should proceed on a statutory claim like RFRA. But I do think there was this strong sense that RFRA was trying even to get kind of our constitutional jurisprudence back in check and back to an appropriate place.
I want to ask a question regarding some of the standards that you have both mentioned. At various points, you've referred to traditional sites of worship or houses of worship or traditional practices. There have been references to churches and synagogues. The First Amendment, of course, doesn't speak to any of those things. The First Amendment speaks only to religion. I wonder if there is a comfortable or uncomfortable relationship with what might have been the historic or even original public understanding of what religion meant and the kinds of scenarios that we're talking about today. Do you see any tension between the historical understanding of what would have been religious in the eyes of the drafters and the ratifiers of the First Amendment and how we're talking and the kinds of things that we're talking about today, public lands for sometimes specific practices?
I'm happy to start this. So I think that there is a real challenge in moving from the original public meaning that was likely understood in the late 18th century of what religion would mean and what it now looks like here in the early 21st century with a much more diverse religious landscape. And if you look at another area of law that involves the religion clauses, so there's the church autonomy doctrine that courts have used this label for basically the idea that both of the religion clauses, free exercise and establishment, protect religious institutions in setting their internal policies, procedures, standards of worship, standards of membership and belonging, and so forth. One of the kind of surprising areas that the courts have not given much guidance on is what counts as a church. Here we have the cases are full of language about religious institutions, kind of like the smaller number of cases that we have here in the land use context are full of talk about sacred sites using various terms to describe these sites. But mostly what we see in the cases is a kind of, I know it when I see it. This looks like a religious assembly that we can recognize. Here's a church, here's a synagogue, here's a mosque. But the further we get from that most familiar paradigm, which is just demographically common in America, the less clear it is that we know how to recognize a religious institution or site or community when we see one. So going forward, I think this is going to be an area that I expect there will be more litigation about in years to come. And I have thoughts on ways of maybe responding to newer and less traditional forms of religion. And I would make a case for having a greater analysis of consent and membership in communities as part of kind of the evidentiary way of trying to recognize these things. But I think these cases, one of the challenges that I think Professor McDaniel and I have both been coming back to repeatedly is that on the one hand, there are longstanding and indeed ancient sacred sites that have long been used, especially by indigenous communities in America. And these have been the center points of a lot of litigation. But in the background, there's concern that, well, there could be any number of spiritual and religious beliefs that people have regarding land and property, and this could become extremely unmanageable. And whether that's just the scary excuse that people are using for then not applying strict scrutiny, which I think would be one take on this, or if that's a legitimate concern that this is a slippery slope and we're not sure we can manage it if we start going down this path. I think that's the hard to predict component of this. And depending on where you fall on that, you might be more inclined to take Professor McDaniel's view or to take the view that I have.
Yeah, so going back to Judge Mady's question of what can we glean from the original understanding, I think whatever that original understanding is, I think protecting worship services and houses of worship would be something that I think you can find a lot of evidence of this, that that was pretty central and pretty core to what the founders were concerned about. If you dig into some of the history in England or even the colonial history that the founders were concerned about, I think some of the instances of government overreach and abuse would have concerned houses of worship. But it's important also, I think, to that we have to apply this in a way that's going to treat all religions equally. So the fact that that most of the instances that the founders would have been concerned about might have been Quaker or Christian or Protestant houses of worship, shouldn't mean that you exclude mosques or synagogues or indigenous sacred sites. And one, I think one take on this that I would recommend looking at is going to the church autonomy context, which I had to smile when Lyle raised that, because I know that's one of his favorite topics. So I knew that he would find a way to bring that doctrine into our discussion. But one of the key cases in that area is Hosanna Tabor. And Justice Alito and Justice Kagan had this really influential, interesting concurrence in that case, where they were looking at if the First Amendment protects so-called ministerial employees of religious institution, if there's this church autonomy principle that requires protecting a church's choice over who should be those ministers, but it's gonna be difficult to figure out who counts as a minister, who doesn't, what type of functions if it's if it's the pastor, that's a pretty obvious example, but sometimes you're going to get more further afield from that. But what Justices Alito and Kagan pointed to is that they pointed out that applying the protection of the First Amendment to roles of religious leadership, worship, ritual, and expression can focus on the objective functions that are important for the autonomy of any religious group, regardless of its beliefs. So I think that's a pretty good list of some of the core functions that the free exercise clause is especially worried about. And at the heart of that, of course, is worship and ritual. So I would say if you look at that evidence, if there's anything that is centrally protected, it would be religious worship and ritual, regardless of what context or what type of place that might occur.
Yeah, the interesting thing about this point seems to be that there's great comfort in identifying traditionally anchored religious practices and places of practice when you talk about the traditions emanating from Christianity and Judaism and Islam. And then there seems to be a similar recognition that a sincerely held belief grounded in morals and ethics and conscience that cropped up tomorrow from one individual person might well fall outside of this kind of scrutiny. And sitting perhaps awkwardly in the middle is traditional tribal practices, which have attributes of some, but perhaps not all of the qualities that we've identified from the others. So why not just take a separate approach to these tribal lands and tribal practices rather than worrying about a one-size-fits-all standard? And do you see the court being willing to experiment something along those lines? Surely there are other aspects of tribal law, of Indian law, that have fit well within the federal system. Is this just simply another area where we should look to that kind of singular solution as opposed to trying to concoct a grand theory that might well have more mischief than sound reasoning to commend to it?
I can start with that. I think that's a possibility. There might be a lot to recommend having I don't know if you wanted to call it like an intermediate scrutiny type approach for these types of cases. I think one argument for that would be the fact that I think indigenous peoples are a categorically very different type of situation when it comes to federal lands, in particular because they have these very ancient ties to the land that may very well predate the federal government's ownership of these lands. They may have practices that are stretching back centuries and centuries. That to me strikes me as different from the situation where somebody comes and says, I've got this religious practice that just started yesterday, and for that reason I need to get onto this military base and go worship on the military base at that particular site, maybe in Area 51. I need to get in there to go practice my religion. I think that the strict scrutiny framework, I think, is capable of balancing that. I think it can be a workable and sensible way to deal with that. But failing that, I think there are special reasons to think that we might think about the indigenous situation differently just because of the federal government's trust responsibilities, and the egregious history of indigenous peoples being divested of their lands, and the fact that they have these really long-standing claims to the land that I think somewhat weaken the government's argument that, well, this is my land, so I can do whatever I want with it. But it seems like there's maybe some tension there with saying, well, there's kind of this competing claim to the land, even if the government technically does have the legal title to the land.
And well, if you could, as part of your response, I'd like to get some of the audience questions in here as well. The professor mentioned this idea of intermediate scrutiny. One of the commentators notes that that's something that an idea that Professor Laycock has sort of suggested in some of his writings. And so is a one-off solution appropriate? And if so, is intermediate scrutiny part of the answer?
Yeah, I very much like the idea of dealing with this as not a one-size-fits-all solution. And this is where I think, again, a statutory approach might be worth experimenting with, something like maybe intermediate scrutiny as a way of, if we think, as I do, that the government has greater authority over its own property than it does when engaged in a regulation that impinges more on traditional kind of negative rights. We're telling you you can or can't do something in your personal capacity. Then maybe something like intermediate scrutiny strikes the balance in a more appropriate way. Another layer to this that I think would be worth thinking about if there were to be a kind of tribal lands RFRA, is just an empirical question that I don't know the answer to, but it is, how often is it the case that there may be overlapping and perhaps conflicting views among tribes on the sacred status of different lands or properties. And so, for instance, in Apache Stronghold in the Ninth Circuit, one thing that was happening underlying this was this land transaction where the federal government is transferring federal lands to a mining company, that they're going to let them do this massive copper mining, as we were already talking about. But in exchange, one thing that we didn't mention yet was that there was an exchange that happened. The copper mining company transferred other lands in Arizona to the federal government that previously had been the copper mines lands, some of which themselves had cultural and religious significance to indigenous tribes. And how to think about something like that, where there's a trade-off and the federal government ends up saying, we're taking these lands and now protecting them that previously had been privately held. And in exchange, we're giving away this other land that had been federal land, and now we're going to allow it to be destroyed. I'm not sure how to think about. It doesn't fit in easily into normal First Amendment categories, which is why one might think that a more specialized statutory framework might provide more tools. For instance, you might think about some guidance in how you think about balancing cultural history and religious observance and ongoing religious observance that might protect if there has to be a trade-off, the one that is more heavily used. But that raises its own concerns about religious discrimination. But these are tough questions, and these are some of the ones that I think can come up when we're dealing with the federal government deciding how to use property over which it has initial responsibility, but for which there are religious claimants.
One of the comments that was received by one of the offered by one of the attendees speaks to this concept of targeting or intentional discrimination. Would animus by the government in the Apache case, for instance, made much of a difference? And I think that's an important question, because one sort of wonders how you balance this question of animus, which could be looked at as sort of disrespect of a particular kind of religious practice, balanced against the sovereign views as the superior need to be used or extracted from the land. So, there seemed to be agreement from both of you that targeting would be fatal to a government's claim. How would that be proven, and how does that work into the standards that both of you are arguing for? We'll start with you, Lel.
Yeah, so targeting is, I think, a basic part of the Employment Division v. Smith framework. And if laws are neutral and generally applicable on this way of looking at the First Amendment, then there's no First Amendment free exercise problem. But if a law is actually designed to target a particular religious group or a particular religious practice, it's not neutral, because they're picking out the person or the group that the lawmaker doesn't like. So that is a pretty fundamental First Amendment affront. It is the government putting its weight against a religious practice or a religious group. And so proving that, sometimes easier than others. You look at examples from the courts. Sometimes there are statements that, for instance, in the Masterpiece Cake Shop case that was ultimately an animus case, there were statements in the record by members of the Colorado Civil Rights Commission saying they were targeting this particular baker to make an example and make a statement about the backwardness of certain religious practices, something to that effect. When you have statements like that, well, there's the smoking gun, and that's pretty easy to show animus. I think you could make a pretty good case, though. Ling is a harder case, but it looks pretty suspect on the particular facts of it, that Congress is picking out a strip of land and says we're designating everything else as wilderness on which you can't build roads. But we're picking this one strip of land saying you can build a road there. And we happen to know that the only people complaining about this road are members of these 3 Native American tribes, which see this as a sacred location. Seems pretty suspect to me. So I think you can have, that's pretty strong circumstantial evidence to my mind. Josh, do you have additional thoughts on this?
Yeah, so I agree with a lot of that. I think targeting is really and animus are both pieces of the employment division versus Smith framework, where you look at whether government action or a law is neutral and generally applicable, and if it isn't either of those things, then that triggers strict scrutiny. That's I think essentially consistent with with the pro position in this case, because I think if you're going to import the Smith framework, I say import all of it. And I think Ling is an interesting case because it actually was cited by Justice Scalia in the Employment Division versus Smith case, and he pointed to it as an example of we're putting this gloss on Ling as a prior case where the law there was not where it was neutral and generally applicable. I'm not sure the court had in mind the separate congressional statute that Lyle is referring to, where Congress identified that specific strip of land. But then, interestingly, I think if you look at other cases like Apache Stronghold, I think both sides of the Ninth Circuit in that case agreed that the law there was not generally applicable, and although you might have a debate about whether there was kind of targeting or whether this was intentional, it at a minimum was singling out a land that happens to be an important religious site, and singling out that land to become basically a crater. And I think applying pretty straightforward post-Smith law in terms of what does lack of neutrality mean? What does lack of general applicability mean? I think that's pretty that would be a pretty straightforward example of a law that triggers strict scrutiny. But then I think going to Lyle's other point about how even the Ling case can be suspect and can be complicated, I think that I think points up the difficulty of saying that we're going to limit it to just a targeting type of exception. The Ninth Circuit tried to do this in the Apache Stronghold case to say like we're going to build in a discrimination exception to this, but I think it's very hard to draw the line between what's animus, what's not animus, what's targeting, what's not targeting. It's a lot more straightforward to just look at is the law generally applicable or not, and if it's not generally applicable, if the government has singled out a particular piece of land for a particular treatment, that's one thing. I think the Ling case, I would argue, is potentially distinguishable because rather than go out and single out the sites of worship in that case for bad treatment, the government went around and tried to identify every site of worship and then placed the road as far as it could from those sites of worship, and then placed protective zones around each of those sites to make sure that there wouldn't be timber harvesting within too close a proximity to any of them. So if anything, I think it was giving kind of most favored treatment to the traditional sites of worship in that case.
We've tackled the current and original understandings of religion. We have glanced at but largely tabled the deconstruction of RFRA. One of our participants says, let's make it more complicated. Why isn't this also speech? Why isn't some of the actions that are being challenged here properly viewed under the remaining parts of the First Amendment? Are there speech issues in here as well? And if so, when can we expect those to crop up in litigation? Josh, you're open, so I'll go back to you first.
I have not seen a speech claim raised in any of these cases. What you do see a lot of is you do see a lot of environmental law claims that are raised alongside these cases. Um, I think uh, the speech case I think I think it's difficult to pull that apart from the religious exercise. So if you're saying that the speech that you're engaged in is uh, the religious speech of the worship that you're doing, then um, I think the analysis would generally um, would generally track. But I think also you start getting into all kinds of thorny questions of given that it's government land, is this a public forum? Is it is it a non-public forum? Has the government opened it up to other types of speech? And my guess is that that would complicate the analysis quite a bit. So perhaps that's why courts stay away from it.
Yeah, completely agree with that. I think one of the other interesting components, you could imagine an argument also that for that there's a conduct as speech claim in some of these cases, to be able to be present and conduct meaningful and expressive activities that can only be done in the presence of certain geological formations or whatnot. But again, I think that would be an experimental claim, shall we say, one that has very little to nothing in the way of case law to back it. You can imagine, putting that in a complaint. So creative plaintiffs' lawyers on this call, try it out and let us know how it goes.
Speaking of trying it out, pity the poor judges that have to wrestle their way through these complicated fact patterns. At several times, you've both offered suggestions that perhaps there could be updates to RFRA, given that it is some 3 decades old. Is this something that realistically lawyers and advocates should be asking for Congress to address, given both the complexity of the religious questions, but also the difficulty of the native sovereignty issues that you've rightfully pointed to? Is there any hope that we could see RFRA 2.0?
Well, I think that the people best positioned to be asking Congress for this would be the tribes and the Department of Justice that end up getting involved in this litigation, and they are the repeat players here. On the part of religious claimants, I think we have a real, it's difficult to imagine organizing around this to try to get change in Congress, just because change in Congress is such a slow, difficult process. And the individual claimants, they're generally firing their one shot in the course of litigation. They're seeking to preserve or protect or provide access to a particular sacred site. It's larger tribes and it's Department of Justice that end up involved in more extensive litigation about these things. And I could imagine that for some of them, it would actually make sense to have a longer term lobbying strategy to try to have maybe a sorting out and a streamlined process that would allow more scrutiny than we get under the Ling framework, but maybe something a little bit less than full-blown strict scrutiny under the pure and unadulterated RFRA analysis. And that might be, not what not each side getting everything that they want, but it might be a better equilibrium than the current one that we're at.
I realized that previously I said intermediate scrutiny might be something that we want to think about, but now that I'm thinking about this through a little more, there may be a couple of reasons to push back on that idea. One is I think you get into dicey territory if you single out particular religious groups for a particular type of judicial scrutiny that is not going to apply in other contexts, whether that scrutiny is higher or lower. And you could get both of those discrepancies if you were to pass such a law. So you could imagine situations where comparable Christian activity might get the benefit of strict scrutiny under RFRA, but you could have the government saying that under this new intermediate scrutiny framework that for the indigenous groups, they don't get the strict scrutiny, they get they get the intermediate scrutiny. And same goes for if you've got situations where RFRA law would say the Christian group or the Jewish group is out of luck. They don't have any strict scrutiny or intermediate scrutiny, but the indigenous groups get it. Then you would have interest. You would at least have questions there about are you running into establishment clause concerns by favoring some religious groups over others? So I think generally the approach has been to try to pass these laws in a way that applies equally across the board. One kind of interesting footnote to that would be that Congress did pass a law called in 1978 called the American Indian Religious Freedom Act. But the thing about that is it doesn't really have teeth in it. It's more kind of recommendatory in nature. So you could imagine Congress passing something like that tries to at least kind of state as like a resolution, like this is the federal government or Congress's view on the kind of the need for protecting these sacred sites. Something like that would probably be constitutional, but you might run into problems if you try to put teeth into it.
Can I just add one thought on this, which is, I mean, very well taken point that there is a real risk here that that any such specialized law would itself be a form of targeting and violate the First Amendment. One possible way around this, you might still face some of these arguments, but to the extent that this is framed not as something about tribal sovereignty, but about the adjudication of religious claims on federal land, so that it would be the same whether it's chapel in a national park or indigenous sacred site. That might at least avoid the targeting of particular religious traditions.
The best conversations are the ones that end too soon. And with that, I want to turn it back over to Professor Harmon for some closing thoughts.
Well, thank you all for your wonderful insights on this important question. Couldn't have asked for a better set of circumstances and for the way this has evolved tonight, and to Judge Mady in particular for your guiding us through the discussion. Josh and Lyle and our student organizations are all we're greatly in your debt for this thought-provoking and engaging event. This will be posted on our website, the library of Seigenthaler debates we've had for the last 4 years. So we're making a nice compendium of First Amendment thought being debated and talked through. Hope you'll look at that website from time to time to see our other conversations on this matters, important thought-provoking matters. With that, in the interest of time, we will end this this debate. But we ask you to please return next year for our 2026 installment of the Seigenthaler debates here at Catholic University's Columbus School of Law. Thank you again to Josh McDaniel, Lyle Weinberger, and Judge Paul Mady on behalf of Catholic Law faculty and myself, A.G. Harmon. Good night.